Hello and warm greetings. Welcome to the Analyst by Vajiram and Ravi, where we would try to comprehensively analyze 7 articles into different sections along with the daily mains answer writing program. In the analysis part, we'll first comprehensively talk about the emergence of white-collar terror in the context of the Red Fort blast, the principal challenges, and the reform measures needed. Then, in the second article, we'll have a comprehensive discussion with respect to the Digital Personal Data Protection Act, the associated issues, and the way forward. Then, in the simplified section, we'll have a look at 5 different articles from a special perspective of UPSC Prelims 2026 along with the value addition. So stay tuned. Coming to the very first topic of today's discussion, this is with respect to doctors with bomb, the white-collar terror. It has often been cited in various articles and academic research papers that economic deprivation, that is poverty, is the sole driver of radicalization. What it means? That if you have a section of society which is impoverished, poor, then that is prone to radicalization. And this has often resulted into terror activities. The conventional held belief that economic deprivation is the primary driver of these terror activities. But what we have been witnessing in the last 2-3 decades is that there has been an emergence of white-collar terror. First of all, what it means? It means that you have certain highly educated professionals, be it the doctors, engineers, surgeons, who are basically orchestrating a particular terror activity, who are planning, who are basically working on the logistics, the movement, the coordination, everything. And then it is leading to the terror activity. Now, what you'll have to understand is that it points towards the fact that economic deprivation is not the sole reasons. There can be possibly other reasons. Now, why we are discussing this is primarily in the context of the cowardly terror attack which has taken place near the Red Fort, which has claimed the life of more than 13 innocent people. Now, again, what you'll have to understand is that the person who has carried out this particular attack, he was a doctor, a highly educated professional, but he was radicalized. So we'll see today what is white-collar terrorism, why it is very dangerous for the society, what are the principal challenges, especially in the context of India, and what should be the policy reform measures required. Now again, one piece of advice, since it's a very sensitive issue, we'll try to keep ourselves restricted with the demands of the UPSC. So whatever content we are going to discuss, that is from the credible sources, the investigative agencies, what we have come to know, right? Now, first of all, what is white-collar terror? White-collar terror means that you have these non-combatants, highly educated individuals, doctors, engineers, IT professionals, surgeons, who are primarily carrying out a particular terror activity. They are planning it and then they are basically executing it. Now, what you have to understand is that they are using their skills, their positions, and their networks in order to enable the financing of the operation, the terror operation, the planning of it, and to legitimize terrorism. That whatever we are doing is correct. Now, see, why this is really important is to understand that once you have a particular person, see, conventionally you have these militants who are usually uneducated. They are radicalized from the childhood days. So that can be, in a sense, you can say that yes, this person is not educated, he was radicalized. But when we are talking about these individuals, these are highly educated people. And you must be surprised that a class 5th dropout, a cleric, a Muslim cleric, he basically indoctrinated these 3 doctors. So these 3 doctors having MBBS degrees, they were indoctrinated by a class 5th dropout. That is the kind of power which radicalization has. In this particular instance, what you'll have to understand is that these people, they not only plan the activity. Usually when we talk about white-collar terror, you'll have to understand this, that these highly educated people, they use others as the combatants, as the field fighters. But in this particular case, the person who detonated that particular explosive near the Red Fort, he himself was a doctor. So in this case, they basically acted as the field fighters. Now, is this a kind of first instance which has happened? No, there are global examples. Now, if we talk about the 9/11 attacks, what you'll have to understand is most of the people, they were graduates and postgraduates in urban planning and architecture. The founder of Al-Qaeda, we had Osama bin Laden. Many people say that he had a degree in civil engineering. His successor, he was a surgeon. So that is what you'll have to understand, that these people are using their skills, the education they have attained. Ideally, they should not have been doing this, but they are utilizing the skills they have gained for this particular act of terror. The government of India has said that this is an act of terror which has happened near the Red Fort. Now, when we are talking about these people, these professionals, they act as ideologues. That is, they propagate a particular ideology. Then they are also the facilitators in terms of providing the financing, in providing the funds or the explosives or the arms, ammunitions, and the fundraisers. So in this particular case, what you'll have to understand that all of them, most of them are doctors, highly educated professionals, and the person who has carried out the attack near the Red Fort, he was one of the persons having a stellar academic record, right? One of the best doctors in Srinagar. And that is the kind of thing which he has committed. Now, the verified facts on the basis of the investigative agencies, what we can say is that the doctors have been the primary orchestrators in this particular act. They have planned and then they have executed this. They were planning for something bigger, right? But the investigative agencies are working upon it. And what we are listening is that they have definitely controlled these things. In these scenario, what we have come to know is that there has been a seizure of a lot of arms. You know, we have AK, Krinkov, assault rifle, which has been basically seized. Then we have a lot of arms and ammunitions. We have magazines, we have detonators, we have timers, which have been found near these, where the places these people were living, right? An explosive in the form of the ammonium nitrate, various chemicals, precursors, that is the substances which are used to basically formulate a particular explosives. In this particular case, ANFO has been used. Allegedly, what they are saying is that ammonium nitrate fuel oil, it's a very potent explosive. This has been used, right? So prima facie, at the very first instance, it looks that there was a particular well-structured network. These people, they were primarily based in Srinagar, but then they went to various parts in the North India, primarily in Saharanpur and in Faridabad, and then they orchestrated a particular act, right? Now, why this is, I told you about the incident, but let's go into the deeper aspect, the demands of GS3, security. There can be a possible question with respect to the white collar terrorism. Why this is particularly important? See, dangerous. When we are talking about the white collar terror, what you have to understand is that it is a kind of a capabilities multiplier, where you are not using a particular uneducated youth. You have a very highly qualified individual who can use his technical expertise, his knowledge of chemistry, his knowledge of medicine, his knowledge of IT, in order to basically plan and execute a terror attack. So this is multiplying the kind of effect it can have, a terror attack can have. Then the logistics, they are using their knowledge, primarily in terms of the IT knowledge they have, in order to create a very robust logistics network. Then the cover. See, generally, if you'll have a person as a doctor or a highly qualified engineer, you'll not suspect that particular person. That would provide your degree. The person's degree would provide as a cover. So it is hard to detect. That is what you'll have to understand. And that's the reason it becomes capabilities multiplier. Then, what are the other reasons? We have financial and administrative access. These people, since they are employed at particular locations, since they are educated, they are not using the wrongful financial methods. They are also using, in many of the cases, they are using the legal financial transactions. Their KYC is done and everything is done. So you'll have to understand that it becomes even harder for the intelligence agencies to basically track these financial transactions, right? Complex financing mechanism. Moreover, they are also taking the route of various NGOs, not just the Hawala networks, the illegal Hawala networks, but they are using charity. For example, there's a woman doctor involved in this particular case. She was the soft face of the whole operation, and she collected a lot of funds in the name of charity, right? That is what you'll have to understand. And they are using both formal as well as informal channels. Generally, whenever we talk about the conventional mode of terror, these people, the militants, they use informal methods, money laundering, through trafficking and other things. But these people are also using the formal banking transactions. So that is what you'll have to understand. Next is radicalization in the elite spaces. Generally, whenever we talk about the radicalization, there is a kind of a specific setup which is there, right? People are radicalized through sermons and other things. But in this particular scenario, what you'll have to understand is that a cleric in the medical college, he basically radicalized the individuals. So universities, workplaces, various professional forums, they are now being used for radicalization. And this radicalization is very hard to detect. Why? Because it is a kind of subtle radicalization which is taking place. It is not taking place in an open environment. So again, allegedly what has been found is what the investigative agencies have said, that we had a particular cleric in Kashmir. He basically radicalized these doctors. And this particular person who exploded this device, Dr. Nabi, he was the one who said that he is not really satisfied with the kind of governance framework we have. And he wanted to establish Islamic law, right? That is what even the Hindu newspaper talks about. Now, what are the principal challenges when we are talking about the white collar terror? The very first is detection and intelligence gaps. See, whenever we are talking about the traditional policing aspect, what you'll have to understand is that it focuses upon certain profiles. Individuals who have a kind of a profile, a militant profile. But when we are talking about these white collar actors, what you'll have to understand is that they are lawfully employed. They have good degrees with them. So they have a respectable position in the society. So it becomes very difficult for these agencies, the intelligence agencies or the law enforcement agencies, to basically detect, to basically nab these people. Then there are coordination issues also. How? See, once things become complex with respect to detecting these people, there are coordination issues also between the state police. Then you have the NIA. Then you have the Intelligence Bureau. So there is a kind of an interaction among these agencies. But if the situation is very complex, if it is really very hard to detect these people, then the coordination issues also arise. Next aspect is the terror financing complexity. These people, they are not just using the illegal forms of transactions, the hawala or the money laundering or other things, but they are also depending upon the legal financial tools. They have, in many of the instances, what has been observed in these investigations is that these people have gone to various countries, Turkey, Saudi Arabia, UAE, and transactions have been carried out through the formal routes. So that becomes very difficult. And what they are usually engaged in a kind of trade-based laundering. So this is not what is illegal, right? So that is an issue. Then this overall thing, it complicates the anti-money laundering aspect. When we are talking about the anti-money laundering and countering the finance for the terror, it becomes very complex because it is not easy to track, to intercept that particular transaction which is being carried out, right? It can be for a good purpose also, right? Because they are using charity, they are using the NGOs and other things. Then there are soft faces, as I've already told you, that there is a woman doctor who was primarily responsible for raising the funds, right? Because she was a soft face in this particular module. Now, next aspect is educational and professional spaces. See, these universities, or let's say the professional networks or the workplaces, they are now emerging as the areas. In certain cases, they're now becoming the areas of subtle radicalization, right? So it's very difficult because these areas, they are focusing upon subtle recruitment. Then they are doing the ideological grooming of the people, right? And then they're also providing the logistics. And again, if you'll imagine a situation where you have these law enforcement agencies or the investigative agencies, if they are going into a particular campus, what would be the condition in India? We would say it very directly that the academic freedom is being curbed. You have police officers coming into the campus and then they are basically doing the investigation. See, again, there has to be a balance. I'm not favoring one or the other. But what I'm telling you is a scenario that in these locations where the kind of surveillance is minimum, for example, the educational institutes or the professional networks, these places are being exploited, right? So that is what you'll have to understand. Next is forensics and explosive controls. In this particular case, there has been large seizure of various precursors. And see, these doctors have utilized their knowledge of medicine. Ideally, they should have used it for the purpose of humanity, for the purpose of saving lives. But what they have done, First of all, they wasted a seat, right? And then what they did, they basically used that particular knowledge system for basically coming up with the precursors, that is the chemicals, the inputs which are needed to create the explosives. So that is something which is very dangerous because they are using their expertise, be it the engineering expertise or the expertise of the chemistry or the information technology. So they have used their skills for this wrong purpose. Then there are supply chain issues. What the investigative agencies have also said is that these people have utilized fertilizers and urea, right? Various fertilizers including urea for preparing the ammonium nitrate. So this is a question mark. This is a question mark with respect to the supply chain. Why these traders and how come these traders sold these fertilizers to these people? That is a question mark, right? Then there are issues with respect to the communication and cyber. See, why we are discussing this is to tell you that if a question comes in GS3 with respect to the emergence of white collar terror, so you can very easily write these points, right? Communications and cyber aspect. These people have used encrypted platforms like Telegram or Threema, right? Hard to detect. It's next to impossible to detect a particular message because the message is encrypted, right? There's a security feature which is enabled. So that becomes really difficult. And they have been using the dark web for fundraising, for basically getting the arms and the other things, right? Arms and ammunitions. Then again, understand, if the government puts controls with respect to these transactions or let's say the communication modes, then people would come, the liberal would come and say that the privacy rights are being compromised. How can the government do that? So again, it is even tough for the government. Understand, it is even tough for the law enforcement agencies, right? Now, what should be the policy responses? Now, see, whenever we are talking about the policy responses, what you'll have to understand is we need to have a framework which respects the rights. Very important. See, we are a democratic country. We have our own set of fundamental rights, primarily in the form of the privacy, primarily in the form of respecting the freedom of expression. So we need to have a balance. But again, at the same time, we need to have a very stringent approach, a very strict approach with respect to these activities. What we have to do? We should basically strengthen the intelligence framework and the forensics. Now, what do we mean by the human? See, when we are talking about this aspect, we're talking about the human intelligence. Generally, it is believed that it is only the responsibility of these intelligence agencies to gather the information, be it the Intelligence Bureau or the RAW, or let's say the other agencies, the state departments. But we have to now work upon the human intelligence, where even the civil society, where we as responsible stakeholders, whenever we come across any information, or whenever we have a kind of a suspicious activity, that should be conveyed to the law enforcement agencies, right? There has to be a proper, robust upgradation with respect to the forensics. Very important, right? Then we have the EOD teams. What do we mean by EOD? We have the explosives ordnance disposal teams. Their capabilities need to be increased. They need to be trained. Why? Because these are the teams who are responsible for neutralizing, for detecting a particular explosive first and then neutralizing it. So their capabilities need to be enhanced. Then the analytics, very important. We are now living in a times of artificial intelligence, machine learning. So why not have a framework where we use a lot of these CCTV cameras and the other electronic equipments and integrate it with the artificial intelligence trained modules so that we have a very robust intelligence backup, right? Then there has to be a crackdown with respect to terror financing. Very, very important aspect. Because see, primarily, these activities happen because they have a source of funding. And they have various sources, not just one single source. And they are using various channels. So there has to be a kind of a trap on these transactions which are being carried out. What we can do is we can have a collaboration among various financial intelligence units in the various countries or in the country itself, right? Various police departments, states, they need to collaborate with respect to this. Then strict norms should be there with respect to the KYC. It should be made even stricter. Then strict monitoring with respect to unusual transactions or suspicious transactions, right? Then targeted sanctions and asset freezes, very, very important. You must have heard about the United Nations Security Council Sanctions Committee. So again, see, the bosses for these people who have been orchestrating these terror activities, they are sitting across the border. Everyone knows that, right? So there has to be a strict enforcement of these sanctions so that there is a kind of a travel ban which is imposed. there should be a kind of asset freeze which should be imposed, right? Next is universities and professional bodies. Very, very important. See there, now when we are talking about the university, see, first of all, we cannot generalize it that, these things are being witnessed in every university or educational institute or every professional workplace. No. What we'll have to understand is we'll have to focus upon the aspect of prevention and not policing. Because, see, we cannot allow policing with respect to the universities and these places, right? So what should we do? There has to be a university-led safeguard. Every university, every educational institute should on its own come with a particular framework. For example, the framework with respect to the monitoring aspect. For example, the framework with respect to the counseling, right? Reporting mechanism, that if a particular suspicious activity is being observed, please report, and on the basis of anonymity, right? So that has to be developed, very important, right? Then the professional councils. Here we are talking about the councils which are related to the engineers, or let's say the doctors or the lawyers or whatever. So these professional bodies, they need to come up with a code of conduct, code of misuse of their professional credentials. So if people are misusing their credentials, if someone is a doctor, someone is an engineer, and if that person is misusing his or her credentials, then that person should be barred from that particular activity, right? Also, what you'll have to understand, that we should incorporate a kind of a mandatory reporting system in various professions, that if you come across any person involved in a particular activity, because in this case also, we have a doctor who has been arrested from Kanpur, right? So they have a very well-defined structure. So that has to be reported, very important. Community engagement and counter violent extremism, very important. There has to be a partnership, as I told you. That's not just the responsibility of these intelligence agencies. It's also the responsibility of the civil society, the religious leaders, the local leaders. We have to basically focus upon the training of the youth. See, understand, this is the kind of demographic dividend we have. It cannot be compromised on this basis, right? It cannot be, left to be radicalized. Because again, if a section of the society, some of its members are being radicalized, we need to find out the reasons. There can be the possibility of insecurity, but that insecurity cannot be allowed to turn into the radicalization of the masses. That is what you'll have to understand. There has to be focus upon the de-radicalization campaigns. In fact, this is something which even the National Security Advisor talks about, that we need to focus upon the de-radicalization aspect. Then the legal and institutional reforms. We need to fast track the legal system, the legal aspect. When I'm talking about the legal aspect, what I'm talking about is not just a domestic case. I'm talking about the mutual legal assistance treaties. Or, see again, we need to reinforce, we need to come up with these treaties. So there can be a faster extradition. There can be the proper cross-border evidence sharing on a fast-track basis. That has to be focused. Cross-border evidence sharing is to be needed. Because, see again, we will definitely submit these evidence as to show to the world that primarily this has been funded and planned in Pakistan itself, right? Because these people, they have gone to various countries, UAE, Saudi, Turkey, right? So again, understand, the leaders or the bosses, the real bosses of this particular act, they are based in Pakistan, allegedly, right? So that is what we'll have to understand. A proper evidence sharing mechanism need to be developed, and we should also collaborate with various agencies. For example, we have the United Nations or the other agencies. And again, there has to be the judicial review aspect. Why I'm focusing on the judicial review? If there are abuses with respect to fundamental rights, if someone's fundamental rights are being compromised, then there has to be there should be a legal recourse with respect to the judicial review aspect. We already have Article 32, we have Article 226. So that is what you'll have to understand. Then international cooperation is very much needed. We are talking about those countries with which India has friendly relations, the European countries. There has to be robust sharing of the intelligence networks, because primarily it has been found in many of the cases. For example, UAE. Now, UAE is a country which has very friendly relations with India. So why not develop a proper mechanism with respect to the intelligence sharing aspect? Track the cross-border flows of these items, arms and ammunitions. Make sure that even the formal transactions are being tracked, right? If they are unusual. Then FATF sanctions, very, very important. In this year, at the start of this year, FATF, Financial Action Task Force, it talked about the white collar terror. It said that it is increasingly difficult to track these transactions. because many of the highly educated professionals are basically participating in these terror modules. So that is something which is very tough. So what you will have to understand, the whole summary is that what we are witnessing now is a kind of a hybrid form of contemporary terrorism, where it is really difficult to nab these persons, to track these persons, to track these financial flows. So what we'll have to do is to come up with a multi-pronged approach, where on one hand we focus upon the intelligence aspect, on the other hand we focus upon the community resilience, we focus upon de-radicalization programs, we make sure that our universities, which are the areas of knowledge, the emergence of knowledge, they should not be converted, right, into areas of subtle radicalization. That is what we'll have to understand. Very important topic, probably can be asked in GS3. UPSC has many times asked these words, what this particular word denote, right? So again, important. Let's have a mains practice question. The emergence of white collar terror poses new challenges to India's counter-terror architecture, right? The emergence of white collar terror poses new challenges. We have discussed the challenges. Discuss. Suggests a calibrated multi-dimensional strategy to address these challenges while safeguarding the civil liberties. The civil liberties must be respected. Very important topic. Do write the answer. And yes, if you're liking the initiative, do not forget to press the like button and also let us know in the comment section. Let's go to the next topic. Coming to the next topic, this is with respect to Digital Personal Data Protection Act, commonly referred to as DPDP Act. Now, it was way back in the year 2017 when the Honorable Supreme Court of India declared right to privacy as an integral part of right to life and personal liberty under Article 21. Now, after that, it was really necessary to incorporate this particular architecture in the various policy aspect. So the government of India appointed a particular committee under the chairmanship of Justice B.N. Sri Krishna to frame a particular Digital Personal Data Act, right? So it came up with its own recommendations, framed a particular draft law. Then this law was referred to a joint parliamentary committee, right? Then the JPC basically gave its own recommendations. And finally, you had the Ministry of Electronics and Information Technology coming up with a particular bill. And this bill was finally passed in the year 2023. Critics say that there are still a lot of issues with respect to this particular bill, this particular act. Yesterday, we had the government of India coming up with the rules with respect to this particular act. Primarily, in simple terms, the act has been implemented with the notification of the rules. But many of these rules would be effective in the later part of the next year. So it becomes really important for us to know what this particular Digital Personal Data Protection Act is all about, right? So that is going to be the model of the discussion. I have taken a lot of infographics sourcing from EY, right? So this would make it very easy for you to understand what the framework of DPDP Act is all about. Now, as I said, the journey began with the Supreme Court declaring right to privacy as an integral part of right to life and personal liberty, and ultimately a committee was formed under the chairmanship of Justice B.N. Sri Krishna, right? And this submitted its report in July 2018. The act, it was introduced in the Lok Sabha and then referred to the JPC, Joint Parliamentary Committee. The JPC released its own draft, and ultimately we had the Ministry of Electronics and Information Technology releases the draft Digital Personal Data Protection Bill in November 2022, and this was finally passed in August 2023. So after a gap of many years. Now, what we'll have to understand is where this particular, first of all, the act says digital personal data. What is personal data? Any data which can reveal someone's identity. That is what is known as the personal data. So where this particular act is applicable, the processing of digital and digitized personal data. Important, pay attention. Processing of personal data within the territory of India and outside. So we are talking about if the processing is taking in India with respect to the Indian citizens and also outside India, that is covered. Activity related to offering goods and services to data principles within India. Now here the word is, the act uses certain important terms. For example, data fiduciary or data principles. Let's talk about that. So what is data principle? An individual to whom the personal data relates. Whoever is holding a personal data of himself, that person is a data principal. A child includes the parents or lawful guardian of such a child. A person with disability includes their lawful guardian acting on their behalf, right? So any person who is having his or her own personal data, that person is to be deemed as a data principal. Who is a data fiduciary? Any person who alone or in conjunction with the other persons determines the purpose and means of processing of personal data. So whoever is processing the data is known as data fiduciary. This can also be important for the prelims, right? And whoever is holding the data, his or her own personal data, that person is known as data principal, right? Then there are data processors. Any person who processes the personal data on behalf of data fiduciary. Let's say we have one data fiduciary and this has given the task. It has outsourced the task with respect to the processing to another entity. So that would be data processor, right? For children's data, we have under the age of 18 years of age, consent is from the parents and the guardians. Then processing outside India. Now this is important to understand. First, what I told you, that it talks about the processing of data both inside and outside with respect to Indian citizens. Then it says activity related to offering goods and services to data principals within India. So if anyone is engaged, let's say I am sourcing services from Amazon or Myntra. So that is what you'll have to understand. I'll be a data principal and my data, which is with Myntra and Amazon, they would be the data fiduciary. I hope it's clear, right? Does not apply to processing for domestic or personal purposes by individuals. Personal data made publicly available. So if you have a set of data which is publicly available, it's not to be applied here. And if someone is doing on personal basis the processing of data, then this would not be applied. Now, this is important to understand. Then we have processing outside India. Now here, one thing is very important to understand. That is a concept with respect to the GDPR, General Data Protection Regulations with respect to European Union. What is GDPR? GDPR is a framework with respect to the protection of the personal data of the individuals in the European Union. It's a very strong framework for the protection of personal data. Now, GDPR follows a mechanism of whitelisting. What it means is that according to the rules, they basically list out those countries to which the data can flow. Those countries can basically process the data. Only those countries which are whitelisted. But through the DPDP Act, what we have gone with is a kind of blacklisting mechanism. What the government is saying is that we will allow the free flow of data to all the countries, except those countries which the government would itself notify. So this is much weaker version of what GDPR is all about. I hope it's clear, right? Then consent is a word, and now this is, we all know consent means that you give the permission to use the data. Organizations should seek a consent. When we are talking about the organizations means what? Data fiduciaries must seek consent with respect to the data principals. If the data principal is a child less than age of 18 years, so his or her parents or the guardians are the data principals. They have the authority, right? Which is freely given, specific, informed and unambiguous indication of the data principal's wishes. You have to convey, you have to ask the consent. You must have seen people ticking the boxes. Install the app, kar do, tick mark. We don't even read the terms and conditions. In the terms and conditions, it is mentioned that we would use all of your personal data. You must have seen whenever you install an app, it says access to the contacts, access to the pictures, the photos, the gallery. So please understand, there is a kind of the exploitative mechanism which is being employed by these data fiduciaries, data processors, right? So whenever you are installing a particular app, make sure that you read the terms and conditions. That's really very important. Consent manager, a consent manager represents the data principal and takes action on behalf when granting, managing or reviewing the content. Then again, when we are talking about the consent, the act says that it should be in a language. You should seek the consent from the data principal in a language in which that person understands. So it can be English or any of the 22 languages as per the 8th schedule of the Indian Constitution. I hope it is clear. We have the data principal, we have data fiduciary who is processing the data, then we have the data processors who on behalf of data fiduciaries are processing, then we have consent managers who give the consent on behalf of data principals, right? So this is the whole framework. And we have not gone with the white listing approach which is followed in GDPR. That is what you'll have to understand. Even a question was asked in the prelims that GDPR relates to which of the following regions. So it's with respect to the European Union. Then legitimate uses and other things. Now, what are the obligations on data fiduciaries? First, engage with the data processor to process personal data on behalf through a valid contract only. Let's say I as a data principal, I have given data to, let's say, a data fiduciary, let's say Amazon. And Amazon is giving my data to a particular entity, third party. So there has to be a proper legal contract between Amazon and the third party. And I as a data principal must be aware of it. There has to be a consent. Then we have provide a clear, concise and comprehensible understandable notice to the data principal, obtain verifiable parental consent before processing the children's personal data, abstain from processing personal data that may cause harm to the children, or undertake the behavioral monitoring of the children or targeted advertising directed at the children. Implement technical and organizational measures to ensure effective adherence with the Act. Now, this is enforced on the data fiduciary, that you need to make your structures robust in conformity with the rules which are notified, in conformity with the provisions of the Act and the rules notified. Report personal data breaches to Data Protection Board and data principals. This is also very important. We'll read about it. Data Protection Board of India, right? Significant data fiduciary. By there can be a particular entity, a small entity, who basically has access to your personal data. And then there can be big entities like Amazon, Myntra, right, who have so much of data, right? So these are to be termed as significant data fiduciaries, and they have added compliance mechanisms. They have to basically be more compliant. Let's go through this. Significant data fiduciary will be determined. How you will determine that which entity is a significant data fiduciary? On the basis of the volume and sensitivity of the personal data processed, risk to the rights of the data principal, potential impact on the sovereignty and integrity of India. Again, these are generic terms. So that is what the critics are also saying, and we'll discuss that these are the generic terms of sovereignty and integrity of India. There has to be a proper definition. Risk to electoral democracy, security of the state, public order. Again, generic terms. Obligations kya hai? What are the obligations which are imposed on the significant data fiduciary? Appoint a data protection officer in India. If you have a particular entity as being designated as significant data fiduciary, then it has to appoint a data protection officer, and he would have certain roles to function. Appoint an independent data auditor for evaluating the compliance, conduct the data protection impact and assessment. A kind of audit mechanism will take place. So we have audit with respect to the financial aspect. So a data protection audit should also be there. Now, what are the rights with respect to data principal? If I have given the data to a particular data fiduciary, what rights I have as a data principal? Simple as that. Right to grievance redressal. If I have a grievance, it must be addressed through a proper channel. Right to nominate. I can nominate that, how my data should be used and who's to be given the responsibility with respect to my data, right? Individuals can nominate any other individual to exercise these rights in the event of death or incapacity. Right to correction and erasure. Again, very important. This has also been highlighted by the Supreme Court in many cases, right? Individuals have the right to correct inaccurate, incomplete data and erase data that is no longer required. Let's say I install a particular app and I only use it once and then I delete that app. But the app, as a data fiduciary, it has my information, my personal data. Years have passed, but it is still using my personal data. So it has to be erased if it is not required anymore. That is what you'll have to understand. Right to information. Data principals have the right to seek information on how their data is processed. I should know that how my data is being processed, where my data is being used. Is it being commercialized or not, right? Personal data breach. A data fiduciary is required to protect personal data, including the processing undertaken by it on its behalf by a data processor, by taking reasonable security safeguards to prevent personal data breach. And if a breach takes place, in the event of a data breach, the data fiduciary needs to notify the board, the Data Protection Board of India, and the affected data principal. If my data has been breached by Amazon, then Amazon should basically notify it to the Data Protection Board of India and to me that your data has been breached. No specific timeline for reporting the breach. Data fiduciaries to inform about the breach in prescribed form. Penalties are imposed. You can see what is the amount which has been imposed. The Data Protection Board, let's go through it. There can be a question in the prelims. The central government may by notification shall appoint and establish an independent board to be called as Data Protection Board of India. The board should consist of a chairperson and other members who should be appointed by the central government. The board is entrusted with the task of enforcement, including the determining of the non-compliances, imposing penalties, issuing directions, and mediation to resolve the dispute between the parties. To ensure compliance with the law. The board is enshrined with the powers of a civil court. So it has the powers of a civil court. It can basically call for witness, and appeals against its decision lie to the Telecom Dispute Settlement and Appellate Tribunal. So if you want to appeal against the rulings of this particular board, then you'll have to go to this particular appellate tribunal, Telecom Disputes Settlement and Appellate Tribunal. Amendments to the prevailing laws. Now, this is again one of the most contentious aspect. Article 43, subclause capital A of the Information Technology Act 2000 is omitted because again it talked about the penalties. Now these have been incorporated in the act itself. Then next thing is section 8 subclause 1 subclause J of the Right to Information Act is amended to exempt the personal information which allows disclosure for public interest. Understand, simple. We have one section of the Right to Information which says that if public interest is overweighting, if it is more in comparison to the disclosure of the personal information, then the personal information can be disclosed if it is for the sake of the public aspect. But what it says, this act makes an amendment. It omits this particular thing. It says that personal information cannot be disclosed under any circumstances. So this is basically hurting the aspects of the Right to Information Act. This act has amended a provision of the Right to Information Act. Now, this is curbing the flow of personal information, even when public interest is supreme, even when it is more. So this, many of the critics, what they're saying is that it is basically a dent. It is a hammer which has been imposed, which has been struck on the Right to Information framework, right? What are the exemptions? Again, a very important point. Processing. Now, there are certain exemptions. Then what do we mean by exceptions? That there would not be any kind of obligations if we are talking about the data processing which is taking place in these scenarios. Processing for the enforcing any legal claim, processing for the performance of any judicial or quasi-judicial functions by any Indian court or tribunal, processing in the interest of the prevention, detection or investigation or prosecution of any offense of any law, processing of data principles outside the territory of India pursuant to any contract entered into with any person outside the territory of India by any person based in India, processing necessary for a merger and amalgamation, similar arrangement or other things. What many critics are saying is that this is too broad. The exemptions are too broad. So in this particular guise, under the guise of these exemptions, a lot of personal data can be used, can be processed, even by the government itself. So there can be a surveillance state, what many critics are saying. So what are the key concerns associated with the act? The very first is excessive state exemptions, as I just talked about. There are a lot of exemptions. So in the guise of those exemptions, a lot of personal data can be used, can be processed. And this would violate the fundamental rights with respect to the privacy aspect. Absence of crucial data rights. See, there has to be, if my data is in one form, there has to be a right of data portability into the another form so that it can be interoperable. That has not been talked in the act. Then we have unrestricted cross-border data flow. So we have gone with a blacklisting approach. We are saying that we will allow the flow of data to all the countries except these countries which are notified by the government. The GDPR follows whitelisting aspect, more restrictive in nature, giving more importance to the personal data. But we have not gone with that, right? So it is again compromising the data security and sovereignty concerns, lack of harm prevention measures. So the act is not talking about the other things. See, we are having a lot of these digital arrests. We have people, calling in on WhatsApp or other things as the police officers from the CBI, from the customs. Aapka saman zabt kar liya hai. Your things, or you have committed a heinous crime. Where are you? I'm coming to catch you. So see, these are the things. But this particular act, it doesn't talk about all these things. How my data has gone to those people. Identity thefts, financial frauds, discriminatory profiling. This is happening, right? So it should have also talked about these things. What measures can be adopted? The very first is clarify the exemption provisions. When we are talking about these exemptions which we have in the form of these things, there has to be a proper definition of each and every word, that in which scenario the data can be exempted, right? Sovereignty and integrity of India, and establish transparent process for granting the exemptions. Promote bilateral data agreements. Again, very important. Whenever India is coming into an agreement with the other country, let's say with Japan, let's say with US, let's say with any country, we should now start highlighting this aspect with respect to data. Because a lot of, India is an emerging market. Many of these MNCs outside India, they see India as a place where they can earn a lot of profits, right? So and that profit is on the basis of the personal data of Indians. So there has to be a proper mechanism that whenever we are coming into deals with the other countries, we need to incorporate this aspect of data also. Ensure regulatory flexibility. We often see that technologies outpace the legal framework. Let's say we have a legal framework now, but suddenly a technology would come. So we'll have to come up with another legal framework. By the time we come with another legal framework or statutory backing, a law, a new technology would come. So there has to be flexibility in the laws so that it can be mended, it can be made in line with the demands of the time, right? That is what you'll have to understand. Evolves with the emerging technologies. Let's say we have artificial intelligence, we have the other technologies that should be incorporated. Adopt global practices such as the EU-US data privacy framework. So as I said, the learnings could have been made with respect to the GDPR, General Data Protection Regulations of the EU, or the kind of AI Act which they have. So we need to go with the global best practices. Again, it is a very good step, but there are issues with respect to this framework, and let's see how things pan out, because now the rules have been issued. Slowly with time, these data fiduciaries, big significant data fiduciaries, would come with their own officers, data protection officers and other things. Let's see how it goes. And with time, what has to be focused upon is making sure that the personal data is protected and it is processed along with the consent of the data principle. That is what should matter, because right to privacy is again an integral aspect of right to life and personal liberty. Let's have a mains practice question. Discuss the various aspects when we're talking about the data principle, fiduciary, right, whitelisting, blacklisting and the other things. With respect to the Digital Personal Data Protection Act of 2023, highlight the possible challenges and suggest a robust way forward. Simple question, 15 marks, 250 words. Do write a particular answer on this question. Let's go to the next section. Coming to the very first topic of the simplified section, we have the Union Minister for Commerce and Industry saying that India is negotiating a lot of free trade agreements with various countries around the world, primarily the developed countries like the United States, European Union, New Zealand and other countries. Now, what you'll have to understand, what he said is that the world is now having a kind of a churning world order. Things are quite chaotic, primarily because of the sanctions which have been imposed by President Trump. So in this particular environment, it is very much good for India and right for India to come up with various free trade agreements, right? Now, see, these trade agreements, they basically talk about the kind of integration we have with the other countries. So they can be classified into various types. Depending upon the kind of integration we have with the other countries, they can be classified. Starting from the preferential trade agreement to that of the free trade agreement, to that of the comprehensive economic partnership agreement. You must have heard about CEPA, right? Then we have the customs union, more integrated. Then we have the common market. And ultimately, we have an economic union, right? So this is the categorization based upon the level of integration we have. Let's go through that. So we have the preferential trade agreement, the PTA. In this, the countries reduce tariffs on a limited set of goods. So not on all goods, but on certain classes of goods, the tariff is reduced. Not on all commodities. It is a least deep form of trade integration. Features selective tariff, means tax concessions, no obligation for zero tariff, flexible and easy to negotiate. For example, we have India Mercosur, right? India Chile, PTA. Then we have the free trade agreement. What does FTA signify? Member countries eliminate tariffs and non-tariff barriers also. So it also includes, see, we generally think it's only about the taxation aspect. No, it also includes the non-tariff barriers. For example, the sanitary and phytosanitary measures, right? Technical barriers to trade, TBT, on substantially all goods in trade. All trade in goods, and often include services and investment. So they are for the goods, but they can also include services and investment. No internal tariffs. Countries maintain independent external tariff. Frequently includes the intellectual property, sanitary and phytosanitary, technical barriers to trade, and e-commerce chapters. Whenever the negotiations take place, these chapters are mentioned in the documents. India, UAE, CEPA, ASEAN, India, FTA, right? Next, we have the Comprehensive Economic Partnership Agreement. As the name says, comprehensive, right? A deeper version of a free trade agreement, covers goods, services, investments, and other things also. For example, regulatory cooperation, mutual recognition, movement of professionals, skilled professionals, for example, right? So we have India-Japan CEPA, we have India-South Korea CEPA, right? CEPA is India's preferred template with advanced economies because it includes the movement of professionals, and we have a lot of skilled professionals. So these terms and conditions are mentioned in the agreement itself, and primarily it is with respect to the developed countries. Then we have Comprehensive Economic Cooperation Agreement, CECA, similar to CEPA, includes broader cooperation areas in the form of technology, education. So it's not only including the trade in goods, services, investments, but rather it's also incorporating the other aspects with respect to technology, education, capacity building, along with trade liberalization. So we have India, Singapore, CECA, India, Malaysia, CECA, right? Then we have customs union. There are some countries who remove the internal tariff. All the internal tariffs are removed and adopt a common external tariff for the non-members. So we have, let's say, 10 countries, internal tariff removed. Now we'll have the same tariff. All of us would have the same tariff for the other countries who are not part of the group. Requires high degree of policy coordination. Supranational body manages the trade policies, right? Then we have European Union or Customs Union. We have Mercosur, right, in Latin America. India is not a part of any customs union. Then we have common market, as the name says, common market. The customs union aspect, we have an internal tariff, right? And we have common external tariff, these countries united, and free movement of labor, capital, services. Harmonized standards with respect to environment, the labor aspects, mobility of factors of production, high institutional integration. So as you go from the aspects of FTA to that of the CECA, right, to that of the customs union, and then to that of the common market, the integration increases. EU single market, CARICOM single market. India has no such deep integration agreements. Finally, we have the economic union, common market plus harmonized monetary and fiscal policies. So in addition to the common market, we are now having one common monetary and fiscal policy. Often includes a single currency, common regulations, right? Example, European Union, Economic and Monetary Union, what we call as Eurozone. India has no such agreements. So that is, see, a question can come in the prelims. That's the reason we have elaborated on the various types of trade agreements. Let's go to the next topic. So coming to the next topic, this is with respect to the National Company Law Appellate Tribunal. So the story is that we have the Chennai bench of the NCLT. So over there, a particular member of this NCLT, while hearing a particular appeal with respect to the insolvency proceedings of a particular company, what he said while hearing the appeal, that a very senior judge of higher judiciary had come to him in order to seek a favorable verdict. Now this information went to the Supreme Court, and in this particular case, the Supreme Court has transferred this particular case to the NCLT bench of Delhi. So let's talk about what this NCLT and NCLAT is all about. Now, when we talk about the NCLT, we can say it as the National Company Law Tribunal, and then we have the appellate body, National Company Law Appellate Tribunal, the appellate body for the NCLT. Establishment and legal basis. The NCLT was established under Section 408 of the Companies Act 2013, became operational in June 2016, functions as quasi-judicial body. It's a tribunal, so obviously it's a quasi-judicial body. NCLAT, established under Section 410 of the Companies Act, also came into effect in 2016 as an appellate body over NCLT decisions. Whenever we have company disputes, any dispute with respect to the functioning of the companies, so it is first heard by the NCLT and then appeal lies to NCLAT. That is what you'll have to understand. Purpose of establishment, both bodies were created as a part of the corporate law reform and insolvency ecosystem. So we have, when companies go bankrupt, there is a kind of insolvency proceeding which is being followed, which has to be followed. So for that, we need a particular structure. So for the reformation of the whole process, we came up with this particular Companies Act, and in the Act, we basically provided for NCLT and NCLAT. Consolidate company law matters under a single tribunal. So we had the company law board before, and this board, it is replaced by the NCLT. Provide faster and specialized adjudication, support the insolvency and bankruptcy code. So IBC code, it is being basically handled for those companies which are having a proceeding with respect to IBC. The case is being dealt by the NCLT, and then the appellate is with respect to the appeal lies to the NCLAT. Composition, the NCLT consists of a president and judicial and technical members appointed by the central government. This can be asked directly in the prelims, so pay attention. NCLAT composed of a chairman and judicial and technical members. Current chairperson, typically a retired Supreme Court or High Court judge. Appointment made by the central government. Jurisdiction and powers, the NCLT original jurisdiction. NCLT adjudicates matter relating to the Companies Act. Any proceeding with respect to the Companies Act, right? Any dispute with respect to that. Insolvency and bankruptcy code. And not just these two laws, but also the other statutes. If the statute of the law itself mentions that the proceedings would be taken by the NCLT, so it does that. For example, the Limited Liability Partnership Act of 2008. Then we have NCLAT, the appellate jurisdiction. NCLAT hears the appeals against NCLT orders. Appeals against the orders of the Insolvency, Bank and Bankruptcy Board of India, right? National Financial Reporting Authority, NFRA, Competition Commission of India, post-amendment in 2017, and also in some cases with respect to the SEBI. Appeals from NCLT go to the Supreme Court. Important point. Do remember, right? So appeal from NCLT goes to NCLT, and then appeal from NCLT goes to Supreme Court. That is what you'll have to understand. Let's go to the next topic. Coming to the next topic, here's a news coming from Gujarat, where Ambaji marble has got the geographical indications tag. Marble from Ambaji, Gujarat's prominent pilgrimage site and Shaktipeeth, has been awarded the geographical indication tag for its high quality white stone, right? The geographical indications registry under the Ministry of Commerce and Industry. So that is how you use the information. The article itself is providing you that what is the jurisdiction with respect to this registry, the geographical indication registry. It's the Ministry of Commerce and Industry. Has granted the tag in the name of Ambaji Marbles Quarry and Factory Association in Banaskantha district. A GI tag recognizes the products that possess unique qualities or characteristics linked to their geographical origin. Let's say if in a particular area a product is being manufactured or is created in that particular area, and it is a specific community in that particular area, it can be given a geographical indication tag that would maintain its unique quality with respect to that particular location. Ambaji marble, known for its shine and beauty, has long been used in construction for religious sites. Ambaji's marble date back to almost 1200 to 1500 years around the time Dilwara Jain temple in Mount Abu was constructed. Right. Let's talk about the geographical indications. Legal basis. Question can be directly asked in the prelims. Governed by the Geographical Indications of Goods Registration and Protection Act of 1999, came into force in 2003, administered by the Geographical Indications Registry, Chennai, under the Department of Promotion of Industry and Internal Trade. DPIIT, Ministry of Commerce and Industry. Also remember the Department of Promotion of Industry and Internal Trade. India adopted the GI protection in compliance with the WTO TRIPS Agreement of 1995. Definition, you can see it is under the GI Act. The World Intellectual Property Organization also recognizes the GI tags as indications that link a product qualities to place-based reputation, environment, culture, traditional skills. For example, we have Tirupati Laddu, we have Pashmina shawls, right? So that is what you will have to understand from Kashmir. What can be registered? GIs can be granted for agricultural goods. For example, we have Darjeeling tea. Natural goods, for example, the Makrana marbles. Manufactured goods like Kanchipuram silk. Handicrafts, Madhubani painting. Food products, for example, we have Bikaneri bhujia, we have Ratlam save. Then the Act allows the registration for the producers, cooperatives, associations of persons, organizations or authorities. In this case, we have association of these people who are manufacturing the marble, right? Enforcement and protection, the rights conferred by the GI registration are exclusive to use for the GI. Right to sue for infringement or misuse, prevents false use of GI or non-authentic good. For example, Banarsi sari from China, right? So this China can do anything, right? China, that is the reason that they have the ability, they have developed the ability to even manufacture these Banarsi saris. So that is what you'll have to understand. And that's the reason GI tags make sure that the product has its authentic origin. That's the reason the GI tags are given. Penalties for infringement. So there are different penalties. Importance and benefits. Protect the traditional knowledge, artisan livelihoods and indigenous cultures. In many of these places which have received the GI tag, the people who are basically working on those communities, they belong to the lower socioeconomic strata. So if you give a GI tag, so they get a good return. That is what you'll have to understand, right? I, as the buyer of a particular commodity, if I am buying a commodity which has a proper GI tag, then amount of it, a certain amount of, a portion of that amount would go to that particular person who has basically contributed in the making of that commodity. Enhances the market recognition and export value, helps prevent the counterfeiting and ensures authenticity, promotes rural development and women-led enterprises, especially the self-help groups. That is what you'll have to understand. Women-led self-help groups. Strengthens India's soft power and global branding. For example, Darjeeling tea, first Indian GI. It can be important. Do remember, this can be asked in the prelims. India's GI landscape. As of 24, India has more than 500 registered geographical indications. Top GI categories are handicrafts, agricultural products, textiles, food products. State who are leading, we have Karnataka, highest number of GIs, and Tamil Nadu and Kerala follow. International protections, protection through TRIPS agreement. Then we have TRIPS means trade-related aspects of intellectual property rights, Lisbon Agreement, bilateral agreements. Some Indian GIs are, for example, we have the Darjeeling tea, enjoy strong protection internationally. We have others, Tirupati Laddu, we have Ponchampalli Ikat, right? We have Pashmina shawls. So just do remember, these GIs can be asked in the prelims. Let's go to the next topic. Coming to the next topic, we have an article talking about the celebrations with respect to Birsa Munda's birth anniversary. Now, PM Modi will visit Gujarat, and it is expected that he would also lay a foundation stone with respect to some of the infra projects. some of the welfare projects with respect to these communities. Now, three important schemes have been highlighted in this particular article. We have PM Janman, that is Pradhan Mantri Janjati Adivasi Nyay Mahabhiyan. Then we have the Dharti Abha Janjatiya Gram Utkarsh Abhiyan. Then we have Eklavya Model Residential Schools. Let's talk about these things, these three schemes. PM Janman, that is Pradhan Mantri Janjati Adivasi Nyay Mahabhiyan, launched in November 23. Ministry of Tribal Affairs target group. This can be asked directly in the prelims. It's not just targeting the STs, it's targeting the particularly vulnerable tribal groups, PVTGs. Coverage 75 PVTGs across 18 states and 1 UT. Tell me the name of the UT. Approximately, the budget is 24,000 crores. Objective to bridge the developmental deficits among the PVTGs. Make sure that you provide the adequate infrastructure to them and other welfare projects. Ensure saturation-based delivery of essential services in remote habitations, right? Major components, basic infrastructure, road, electricity, pipe drinking water. For example, we have PM Awas, then we have health, mobile units, right? Then we have telemedicine, anemia. We have, when we talk about the telemedicine, we have the e-Sanjeevani portal. Education, livelihood economy, the minor forest produce procurement, right? Micro enterprises, giving them small amount of money so that they can come up with their own enterprises. Skill development, digital and financial inclusion, banking access, mobile connectivity in these remote corners, habitat rights, support the FRA, that is the Forest Rights Act for these STs and traditional and forest dwellers, right? Then we have Dharti Abha Janjatiya Gram Utkarsh Abhiyan, launched by Ministry of Tribal Affairs as a part of tribal-centric economic empowerment, a national-level community development program for tribal villages aligned with the larger goal of Jan Bhagidari plus Jan Andolan, a community-centric driven program. Who is Dharti Abha? Birsa Munda, revered tribal freedom fighter, is popularly known as Dharti Abha, father of the earth. The name symbolizes the self-governance, dignity, and socio-economic upliftment of Adivasis, of tribals. Aim of DAGJGWA to transform the tribal villages into sustainable, self-reliant Gram Utkarsh clusters by focusing upon economic empowerment, livelihood generation via forest produce, agro-based industries, handicrafts, promotion of Vandhan Vikas Kendras, which are the centers with respect to the minor forest produce. We have betel leaves and other things, tendu leaves. Strengthening the local governance, empowering the Gram Sabhas and scheduled areas under PISA, Panchayat extension to scheduled areas, training for community-based planning and resource management. Social infrastructure, access to education, health, nutrition, skill development, market-oriented skilling. Then we have convergence approach, integrate schemes of tribal affairs, rural development, Panchayat. So it's an inter-ministerial collaborative effort, right? Then we have EMRS, very old scheme, focuses upon the tribal students. Started in 97-98. To provide quality residential education. So it provides residential education to ST children, scheduled tribes children at par with the Navodaya Vidyalayas. One EMRS per block with more than 20,000 ST population and more than 50% ST concentration. Current target of establishing more than 740 EMRS schools across India. Features caters to those students from class 6 to 12th. Free education, lodging, books, uniforms. Focus on ST girl education and ST talent identification, equipped with the STEM labs, that is the science, technology, engineering, mathematics, sports complexes, smart classrooms, right? E-learning modules. Governance managed by the National EMRS Society under Ministry of Tribal Affairs, 100% centrally funded. This you should understand, because sometimes the questions also assess that whether you know the funding mechanism of a scheme or not. Significance, helps reduce the dropout rates among the ST students, provides pathways for higher education, sports, competitive examination, major tool for social mobility among the tribal communities. Social mobility is again very important component with respect to socio-economic development. That is what you have to know. Let's go to the next topic. Coming to the last topic of today's discussion, here is a mention of Taiwan. So US has approved the sale of military components worth more than $330 million to Taiwan. The United States has approved $330 million worth of parts and components in its first military sale to Taiwan since US President Donald Trump returns to the office. Know that Washington is Taipei's biggest arms supplier. So we will look at the geography of Taiwan, and also we have a mention of Strait of Hormuz, right? So there are tensions again spiraling in the Strait of Hormuz. So if you just look at this particular map, it is adjoining China, right? Taiwan, we have East China Sea on the upper side, then we have the South China Sea. Now if you look at this particular map, we have East China Sea over here, we have the Taiwan Strait between China and Taiwan, then we have South China Sea over here, then we have Pacific Ocean on the right side, and then we have Luzon Strait just below Taiwan. That is what you have to understand. Next important thing is the Strait of Hormuz. Now if you just look at this particular map, Strait of Hormuz is a very important geostrategic point, primarily because a lot of oil supplies are through the Strait of Hormuz, right? And there are tensions in the region, primarily between because of the confrontation between Iran and Israel, and also we have the US who's supporting Israel, right? So this is what you'll have to understand. Strait of Hormuz. It looks as if it's between Iran and UAE, but it's not between Iran and UAE. It's between Iran and Oman. Remember, Iran and Oman. Oman. So this is a part of the upper territory, it's a part of Oman, right? Again, what is important to understand is the mention of this particular port, Bandar Abbas, if you can see, right? So this is important, and it is a very important port with respect to the trade and logistics aspect of Iran, because it connects then to the Central Asian countries, right? So there are tensions in the Strait of Hormuz, and it can also compromise the supply, the global supply of oil to different countries, including India and China. That is what you have to know. Important. You can just have a look at the other areas also. So that is it for today. I hope you really enjoyed the discussion. If you did, let us know in the comments. All the very best. Thank you.